Welcome to Redisclosing Children, Youth, and Family Information. The How, the When, and the Why. This webinar is sponsored by the National Juvenile Information Sharing Initiative and the Office of Juvenile Justice and Delinquency Prevention. This webinar will focus on the redisclosure of information, specifically in a juvenile information sharing environment, and will also focus on HIPAA, FERPA, and substance abuse specific provisions around redisclosure of information. This webinar is presented by Susan Lineski, Privacy and Confidentiality Specialist with the National Juvenile Information Sharing Initiative.
Timely, accurate, and complete health, medical, educational, and substance abuse information must be collected, maintained, and made available to members of an individual juvenile's assessment team so those members can accurately diagnose and care for the individual, as well as provide assessments and referrals for other juvenile justice services. While most consumers and parents understand and have no objection to the sharing of this information, there is also a concern that data that is confidential and private is being shared inappropriately. Consumers may not be aware of the fact that their personal information and that of their children can also be used when it is shared in this situation as a legal document that describes the care rendered, to be used for verification of services, as a tool in evaluating the adequacy and appropriateness of care, as a tool for educating health, substance abuse, mental health, and other juvenile justice professionals, and as a source of data for research. Although consumers trust the juvenile justice agencies to maintain the privacy of the personal data that is provided and maintained, they're often skeptical about the actual security of this information when it is maintained electronically or disclosed to others. Increasingly, consumers want to be informed about which information is collected and how they can have some control over their information. One of the greatest areas of concern is redisclosure. In this presentation, we're going to touch lightly on actual disclosure and dissemination of information, but that is really the topic of other sessions. This session will concentrate on the redisclosure, the secondary dissemination and disclosure of data after it has already been shared with a single agency under consent or under emergency situations. Statutory materials, backup quotations, access to URLs, and electronic resources will be provided under separate cover. Some juvenile justice case scenarios and examples will be discussed in this session. However, detailed use cases and state collaborative specific scenarios are the topic of a different session. This presentation assumes a basic knowledge of HIPAA, FERPA, and federal substance abuse provisions. In this presentation, we're going to talk about redisclosure. What is redisclosure? How does it happen and when? And what are the restrictions on redisclosure of data that is protected by federal statutes such as HIPAA, FERPA, and substance abuse? There's also a question about whether or not consent is required for redisclosure, as it is for initial disclosure of HIPAA, FERPA, or substance abuse data. And where available, we're going to provide some information on best practices and available resources to assist you in the future. So what is redisclosure? Redisclosure, in a general sense, is the act of sharing or releasing information that was received from another source, such as an external facility, a healthcare provider, a different agency, a juvenile justice advocate, or any other place where that data was collected and is then disclosed and made part of that agency's record for the juvenile, or is included in a group of records that is maintained for or by that agency, which is used in whole or part to make decisions about the juvenile. In other words, it's the re-access to that data, redissemination, or secondary release. Organizations must understand that their redisclosure responsibilities under federal and state laws, which include HIPAA, FERPA, Substance Abuse CFR 42, Part 2, and the Privacy Act and related state laws, is closely guarded and is different in many cases from actual disclosure and consent provisions. The Privacy Act of 1974, for example, requires that federal agencies and organizations that collect and maintain information on behalf of the federal government also provide individuals with a notice of what is protected data and what your rights as an individual are to release or disclose this data. This notice, which we often call a consent form in juvenile justice, relates to identifying what the statute, order, or law is that authorizes the government to request you to share this data, what are the principal purposes for which this data is going to be used, what are the routine or ancillary purposes that this data may be used for, and is this notice provided in a written form, is the information solicited, and what sort of separate data can this information be used for in the future. While states may have their own laws and regulations relative to redisclosure for all or some particular sensitive types of juvenile justice data, state law does not always preempt. State law may preempt HIPAA when the state law provides stricter confidentiality protections or provides patients and students or juveniles who are subject to HIPAA with a greater right of access to their health data. And it also does not preempt substance abuse law where there is a specific right to protection and confidentiality of that data, such as in the case of substance abuse, mental health, psychotherapy, or psychiatric situations. There are also regulations regarding the redisclosure of data without consent for matters of child welfare, foster care, or in abuse and neglect situations. FERPA law may preempt HIPAA as a funding statute, and state law may not preempt federal substance abuse regulations. So why is redisclosure an issue for juvenile justice? Because of the varying procedures, state laws, and federal rules around specific types of data that may be involved in the juvenile justice information sharing system, we have to look at the differences between these laws and where these laws conflict and where these laws go together to support juvenile justice sharing. Remember, unlike a single transaction, such as a single medical exam, school report card, or a single instance of providing data about a treatment or a test, juvenile justice involves the assessment, treatment, and activities that are related to processing the juvenile through the justice system in a family and community environment over a long period of time, and may involve multiple agencies and record sources at different times. How does redisclosure happen and when? There are many different ways in which redisclosure can occur: inadvertently, authorized, unauthorized, mandated, or appropriately. This data can be redisclosed as part of a transfer or sharing of a bulk record, such as sending an entire record forward. It can happen authorized or unauthorized, in other words, with or without consent. It can be sent to assist in further analysis, investigation, diagnosis, etc., and that may be mandated by specific laws and procedures. And it can be disclosed appropriately or inappropriately. We use the words appropriately and inappropriately most often when we're talking about emergency situations involving health and safety. To help define if the redisclosure or the redissemination is authorized, we must look to why that data was being disclosed and if consent was required. In other words, why did it happen and when did it happen? The most common questions that are asked when we look to redisclose juvenile data is the consent required? Initially, there was a consent in most instances to disclose this data the first time around. Now that this data is being redisseminated or redisclosed or shared by to a third party, we have to ask questions again related to consent. Must the data consent forms initially provided and signed by the parent or the minor who has authority actually address that this data may be redisclosed at a future point in time or shared with other agencies? Do the federal and state statutes address redisclosure generally or specifically by types of data? Are there exceptions, as there are in consent for disclosure, that will authorize redisclosure, such as in an emergency situation with a court order for a specific treatment need, or in other situations where there is a health or safety threat? Is there an obligation or restriction on the agency receiving that juvenile data to protect the individual's privacy by safeguarding that information and not redisclosing what was initially provided? Can redisclosure be prevented? Can it be restricted? And are there penalties that exist that parties involved in redisclosure should be aware of? To understand these questions, we have to look a little bit further into the definitions of privacy, confidentiality, and consent, and also look at what are some of the definitions of the data, the types of data that we are going to be considering redisclosure. Confidentiality as a term in this situation relates to the management of another individual's personally identifiable information. Privacy refers to the obligations that those who receive this information have to respect this individual's privacy by safeguarding that data. An important distinction to remember is that privacy pertains to individuals, whereas confidentiality pertains to their information. So, is redisclosure a violation of privacy or of confidentiality? In many cases, it's both. Some laws are more specific than others in defining these principles, so we will look first individually at HIPAA, FERPA, and substance abuse regulations that address the specific data and disclosure and redisclosure of that type of data covered by that type of law, in other words, mental health, medical, substance abuse, and educational. And then we will look at what kind of shared policies exist to consolidate or coordinate the redisclosure across the processing of the juvenile justice area. The first place we look is at the HIPAA privacy rule. The HIPAA privacy rule defines health information as any information, whether oral or recorded, in any form or medium that is created or received by a healthcare provider, a health plan, a public health authority, an employer, and a life insurer, a school or university, or a healthcare clearinghouse. And that information is related to the individual's record, whether it is current, past, or future physical or mental health condition of the individual, whether it regards the actual provision of the health care to the individual, or the past, present, or future payment of those health care services. So the rule in HIPAA regarding health information relates specifically to consent and authorizations that address this type of data, this type of health care and medical and mental health data that may be subject to disclosure initially through consent, and then possibly subject to redisclosure, and at that point may no longer be protected by the initial rule. The privacy rule's minimum necessary requirements should be followed to ensure that healthcare data is not inappropriately disclosed. HIPAA does include definitions of disclosures and redisclosures, and the rules say that a valid authorization must include a statement that the information used or disclosed pursuant to an authorization may be subject to redisclosure and thereby no longer protected by the rule. So initial consent forms signed in the juvenile justice area that regard HIPAA data should include on that consent form this disclaimer that this data may no longer be protected if it is disclosed to a third party, in other words, redisclosed. Redisclosure under HIPAA is defined as the act of sharing or releasing health information that was received from another source and made part of the patient's health record or the organization's designated record set. The designated record set, as we've talked about before, is a group of records. This may be the entire patient file. This may be a manual record. This may be an automated record, or it may be a compilation of both. Think about it as the standpoint of as a person is getting health care or receiving diagnosis or assessment or referrals, a record and the copies of the reports that are produced by attending physicians are often sent to other places. So an attending physician at a hospital will produce a report and then send that report as part of the patient's file to the actual hospital ward and the physician where that individual is being processed, being admitted, being served with an operation, treatment, etc. Similarly, as reports are compiled during that patient's hospitalization, those reports will be included in the overall medical file and may be sent further to assist in continued patient care. So let's take an example in HIPAA about redisclosure. We received a question from a healthcare provider that said, when a patient requests a copy of her healthcare records for her child and is getting ready to transfer care of that child to another provider, we, as a healthcare provider, have always created an overall record and transferred that whole health record to the next provider. If a parent comes in and requests copies of the healthcare records, does she only get the records brought with her for her first visit, or does she receive the whole chart? Because this would include both information that the parent provided and other information from prior sources. The answer is yes. The parent can be provided with all of the records because the records were made part of the child's designated record set. So they may be disclosed upon authorization to the individual, in this case the parent, who consented to them originally. However, we must remember that though we are redisclosing healthcare information that's necessary for patient care, if there is a concern that the parent may be involved in an abuse and neglect situation, if there is data in there such as substance abuse data that is subject to separate provisions, we need to make sure that data is protected. And we'll discuss